I call this meeting to order. Welcome to meeting number 10 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to a motion adopted on Tuesday, February 8th, committee is meeting on the Review and the Protection of Communities and Exploited Persons Act. Today's meeting is taking place in hybrid format, pursuant to House Order of November 25th, 2021. Members attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. I'd now like to welcome our witnesses, but before I do, just want to let them know I use little cards. So when you're at your last 30 seconds, just look for the card, and then when you're out of time, and I don't like interjecting, so I hope you just adhere to the timelines. We have, it's good morning to our guests from New Zealand. I understand that's Dr. Gillian Abel and Dr. Lindsay Armstrong. We also have, so thank you so much for joining us from the bottom of the world, or the other side of the world, I should say. And Professor Janine Benedet from University of British Columbia, and Nadia Guo from the criminal defense lawyer. We also have from the Center to End All Sexual Exploitation, Kathleen Quinn. So I'm going to give you all 5 minutes each. We'll start with Dr. Abel from New Zealand. 5 minutes, please.
Thank you very much. I'm Dr. Gillian Abel. I'm a professor of public health at the University of Otago in New Zealand. And I've been doing research in the field of sex work for around 25 years, and I'm considered a global expert in this field. So sex work in New Zealand was decriminalised in 2003, but I did my first project in the late 1990s when sex workers' activities were still criminalised in New Zealand. And this research demonstrated that criminalisation of sex workers' activities was responsible for a number of harms. Street-based sex workers experienced more and more severe forms of violence than indoor workers because they had no time to assess whether a client was safe or not before getting into the car, as they were scared that they would be spotted by police. Parlours were working under extremely exploitative and coercive conditions. They fight for better working conditions, and they couldn't report crimes committed against them to the police without exposing themselves as involved in an illegal activity. In addition, police used the presence of condoms within parlours or the carrying of condoms as evidence for prostitution-related activities, which created a disincentive for their use. So all of them, and people know that they can get away with coercion, exploitation, and violence when their victims have little access to legal and human rights. So the evidence we obtained in our research was valuable in strengthening the case for a change in the way sex work was legislated for in New Zealand. And in 2003, all laws which criminalised sex work activities were scrapped. The argument for decriminalisation in Parliament was that sex work was not inherently dangerous, but the laws created the danger. Decriminalisation was argued for as a harm minimisation strategy. The Prostitution Reform Bill was enacted, and its stated aims are to safeguard the human rights of sex workers and protect them from exploitation and promote the welfare and occupational health and safety of sex workers. I conducted a large study 5 years after the Act was passed, which included a survey of 772 sex workers and in-depth interviews with 57. We also did an estimation of the number of sex workers in 5 cities in New Zealand. Council of New Zealand and the Ministry of Justice, and I was contracted by the Ministry of Justice to produce a report for the evaluation of the Act. The Prostitution Review Committee set up by the Ministry of Justice concluded that the Act had been effective in achieving its purposes and that most sex workers were better off than they were when their activities were criminalised. Since then, I've carried out many other studies looking at experiences of sex workers exiting sex work, interactions between social workers and young street-based sex workers, employment practices in brothels, work practices and safety of internet-based sex workers, migrant sex workers' experiences of working in New Zealand, and street-based sex work in the community. It'll be 20 years next year since sex work was decriminalised in New Zealand, and I can categorically state that sex workers are far better off than they were when I undertook that study, that first study in the 1990s. There's no political will to change the status quo, Anecdotally, members of parliament who voted against decriminalisation back in 2003 now say that their concerns were unfounded and they would not support change. There's exploitation in many forms of employment. It's not confined to sex work, but previously, unlike other workers, sex workers had no recourse to justice. They're now aware of their rights, which has resulted in a shift in power between brothel operators and sex workers. Some sex workers have taken operators to the Human Rights Tribunal when they have tried to impinge on their rights. Other cases have been settled through mediation. They have the right of refusal to provide commercial sexual services, and consent can be withdrawn at any stage in the transaction. They indicate to operators they are prepared to excuse me, got a frog in my throat. They indicate what services they're prepared to offer clients, and clients are informed of this before they book a particular sex worker. This reduces the chance of a client resorting to violence because of unmet expectations. Street-based sex workers welcome well-lit areas and CCTV cameras as making their workplace environment safer. They're able to take their time assessing whether the client is sober, has no obvious weapons in the car, and nobody else hiding in the back seat. They can also negotiate what services they're prepared to provide before getting in the car. The relationship between police and sex workers is much improved, and they are no longer seen as the enemy. Sex workers are more proactive in reporting incidents to the police, and there's a better dialogue between them. This has been collaborative initiatives between police and the New Zealand Prostitutes Collective, which is the sex workers organisation in New Zealand. This is not to say that things are perfect. One aspect in which the Prostitution Reform Act has failed is Section 19, which deals with the application of the Immigration Act. It stipulates that no permit can be granted to a non-resident who provides or intends to provide commercial sexual services, or who intends to operate or invest in a commercial sexual business. Migrant sex work, violence and exploitation.
Dr. Abel, I'm going to unfortunately have to cut you up, but it will hopefully some of the members here will allow you in their questioning to answer some of the questions coming up. I'll next ask Dr. Lindsay Armstrong for 5 minutes.
Thank you. So my name is Dr. Lindsay Armstrong, and I am a senior lecturer in criminology at Victoria University of Wellington in New Zealand. My research focuses on how laws impact the rights, safety and well-being of sex workers, and I began doing research in New Zealand in 2007. I'm going to talk about the decriminalisation of sex work in New Zealand, drawing on research and case examples which highlight its impacts. I will also discuss the limitations of the legislation. New Zealand decriminalised sex work in 2003 with the passing of the Prostitution Reform Act. The purpose of the legislation was to better support the occupational health and safety of sex workers. And the legislation was drafted with the input of sex workers, with the New Zealand Prostitutes Collective involved in drafting earlier versions of the legislation. Since the law passed in 2003, several studies have highlighted the positive impacts of decriminalisation in New Zealand. Research conducted by Gillian Abel and colleagues to evaluate the impacts of the law after its enactment found that a majority of participants felt that they had more rights and that they were more able to refuse to see clients since the law had changed. Several participants also felt that police attitudes towards them had improved. Subsequent research that I have undertaken with sex workers has indicated that relationships between street-based sex workers and police have improved, and that decriminalisation better supports the safety strategies of street-based sex workers. Since neither sex workers nor their clients are criminalised, interactions can be openly conducted and conversations can be explicit, enabling sex workers to take their time when screening clients. In my most recent research in New Zealand, a majority of the 46 sex workers we interviewed described feeling that they had more autonomy and control in their work in a decriminalised framework, and overwhelmingly spoke about decriminalisation having had a positive impact on their well-being. While the clients of sex workers remain an under-researched population in New Zealand, a qualitative study of 12 clients of sex workers found that those interviewed were aware of the rights of sex workers and conveyed respect for those rights in how they described their interactions. Positive impacts of decriminalisation have also been evident in several high-profile court cases. For example, in 2014 and 2020, sex workers won sexual harassment cases in the context of their work. And in 2021, a man who covertly removed his condom during sex with a sex worker was convicted of rape. While sex workers can still experience violence in the decriminalised context, the legal framework better supports their safety strategy and strengthens access to justice for those who do have adverse experiences. Thus, the evidence to date overwhelmingly indicates that the decriminalisation of sex work has had positive impacts on sex workers. Research conducted in New Zealand over the past 2 decades has led me to conclude that full decriminalisation is the legislative model that best supports the safety, rights and well-being of sex workers. While there have been many benefits, the decriminalised model in New Zealand also has limitations. Section 19 of the Prostitution Reform Act prohibits temporary migrants from working in the sex industry, even if a person holds a visa that enables them to work. This means that temporary migrants who are working in the sex industry are working illegally and do not benefit from the protections of the Prostitution Reform Act that are afforded to permanent residents and citizens. Their illegal status means that there is a barrier to them reporting adverse experiences due to a fear that they may be deported if they come to the attention of authorities. Stigma is also an issue that endures, and there's no legal protection from discrimination for sex workers on the basis of their work in New Zealand. The legal framework would be strengthened by repealing Section 19 of the Prostitution Reform Act so that migrant workers have the same rights and protections as other workers. Legal protection from discrimination would also benefit sex workers in this context. Thank you for the opportunity to speak today, and I welcome any questions that you have.
Armstrong. Next, Professor Janine Benedette from UBC Law for 5.
Thank you to the committee for inviting me to participate in these hearings. As you know, I'm a professor of law at the University of British Columbia and a member of the British Columbia Bar. Bringing a sex equality analysis to bear, I advocated in favor of the criminal code offenses against male buyers and pimps that were added to the criminal code in 2014, and believe that they need consistent enforcement along with public education and supports for prostituted people. This asymmetrical equality model has been adopted, as you know, by a number of countries successfully, pioneered by Nordic countries, which are the most gender equal countries in the world. In my brief time with these opening remarks, I would make 3 simple points. The first is that the prostitution industry is structured as a practice of sex inequality and also of racial and class inequality. And this reality is continuously obscured by resort to the gender-neutral clinical language of sex worker and client, manager, and third-party operator. The reality is that it is men who are buying. They buy women and girls, sometimes boys, other men, and transgender people. The women and girls that men buy for sex in this country are disproportionately young, Indigenous, and poor. And they are the people that we need to be focusing our legislative efforts on. We all know this. And yet you are being asked to decriminalize sex purchase, pimping, and procuring. Well, I ask what happens when there are not enough Canadian women who will resort to prostitution to meet this legalized, validated demand. What happens is that we will traffic women into prostitution, we will scoop girls up from state care, and we will import women from the inexhaustible supply of poor women in other countries. More of all of these things will happen if demand is legalized. Canada is not an isolated island. It is a country that shares a large, porous land border with hundreds of millions of American men who will also take advantage of this legalized market. The second point that I would make to you today is that the silence of the Johns before this committee is deafening. The centerpiece of the 2014 amendments is the direct criminalization of sex purchase. Despite this, and despite the fact that Johns outnumber those in prostitution by many orders of magnitude, they remain largely invisible. They're not appearing before this committee to defend their insistence on being able to buy sex on demand from a woman who does not want that sex, only the money that they have and she needs. Instead, they hide behind women in prostitution, shifting the focus onto them as if their demand is somehow natural and unchangeable, like the tides or the seasons. They get to hide behind the concerns for the very safety of the women that they are harming. We can acknowledge women's decisions to enter the sex trade in the face of whatever constraints they might face without validating the choice of these men to buy sex. And finally, I would say that it is male sexual entitlement that is at the root of sex purchase. This is a key barrier to women's equality in Canada generally. We criminalize sexual assault, but more than 99% of sexual assaults result in no criminal consequences for the perpetrator. The Me Too movement is just the latest expression of decades of organizing against the impunity for male sexual violence, impunity that fuels male sexual entitlement. I would argue to this committee, and in fact, I argued in my written submission, that prostitution itself is a form of sexual harassment in which being groped or otherwise used sexually becomes the condition of work. We recognize that as a violation of women's human rights in other spheres, but we don't seem to recognize it for prostitution. When men who buy sex are asked what would stop them, they consistently say a real risk of punishment and publicity. I do not want to legitimize male sexual entitlement. I don't want to make it permissible for men to buy a submissive Asian woman, an Indigenous woman to act out their colonial fantasies, or some kind of group sexual encounter as a male bonding ritual with their friends. Telling men that they can do this without consequences does not make women safe, and it does not make women equal. Decreasing demand does. So talking about how to make things a little less bad for some small subset of women who these men buy completely misses the point. We can and must do better for Canadian women than this unrestricted male market in women's bodies, and the liberty and equality of all Canadian women depend on it. Thank you.
Thank you, Professor Benedette. Now to Nadia Gu, if I said that right, for 5 minutes.
Yeah, it's Guo.
Guo.
Okay, I'm a criminal defense lawyer based in Toronto. I also worked as an independent escort both before PISIPA was enacted and again after it was passed, advertising online and working both in calls and out calls. A unanimous panel of the Ontario Court of Appeal in the recent decision, the Queen against NS, which was released February of this year, found a majority of the PISIPA criminal provisions to be constitutional and not in violations of Section 7, 2B, and 2D of the Charter. The decision made sense to me given the limitations of Charter jurisprudence in addressing the problems inherent in this legislation. The ultimate issue is that the criminal prohibitions are compliant with Section 7, even if the provisions do nothing to actually achieve their purpose or the overall objective of the Act, which is supposedly the eradication of all prostitution. Therefore, in my view, legislative action is required for any meaningful changes. I struggled a bit with what I was going to say today because the truth is independent sex workers like myself probably have more freedom to sell sex currently under PISIPA than they would in a regulated industry. I saw what the Cannabis Act did to small-scale growers, and I fear independent sex workers may face similar challenges in a regulatory environment. Personally, I noticed no differences in the industry between how it was before the laws were passed as opposed to how things were afterwards. Men continued to pay for sex just as eagerly as they always did. Third parties like escort agencies continued to operate. I was able to advertise and screen just as effectively as before. But though not much changed for me, there are other reasons I think some of the criminal provisions should be repealed. I worked on a Section 286.1 appeal last year where I had a firsthand look into how police went about enforcing the laws against clients. Much of it depended on if you lived in a progressive metropolitan city where police have real crimes to focus on, as opposed to a less populated rural town where police are more motivated to make arrests. If you didn't speak English very well, you're less versed in the industry know-how of how to discern real ads from fake ones. The stings are exclusively relegated to classified list, where the average rates are less expensive and half-hour and 15-minute bookings are more common. Essentially, those unlucky enough to get arrested tend to be less well-educated, less white, and less well-off, which mirrors the trends in the criminal justice system itself. Several courts have also found the mandatory minimum sentences in the legislation to be unconstitutional. The sentences in Section 286.1 begins at a $500 fine for a first summary offense. This means unless a Crown agrees to withdraw the charge, you will receive a criminal record for life and significant hurdles to securing future employment. Not to mention, by the logic of this legislation, you're now branded a sexual predator responsible for the exploitation of helpless women. Paradoxically, this also means that you can assault a sex worker and potentially receive no record, but not if he had simply contacted or paid for the services she is voluntarily offering. The injustice of this legislation is surface level, and you don't need a law degree to understand it. Are we okay with criminalizing people for buying something that others happily and legally sell? Are we okay with giving police departments the discretion of enforcing a law that can ruin people's lives and careers? The simple fact of the matter is that the criminal law has never deterred men from wanting to pay for sex. It certainly hasn't in the US, where Canadian sex workers travel to regularly to work illegally in order to access the healthy demand there. The sex worker rights movement has gained a lot of momentum since this law was passed. The more visibility sex workers gain in society, the harder it is for anyone to continue to justifiably claim that we aren't just doing it consensually, but that we also highly prefer it to other forms of work. There's a lot of hysterics and exaggeration on both sides of this debate, and in my opinion, there are good policy reasons to have both a legalized and regulated industry, as well as that one that prohibits commercial enterprises based on third-party profiteering. But I can say without a doubt that the internal logic of PISIPA claiming there is sex exploitation inherent in prostitution is flawed. Certainly, I've never experienced it, and that the end demand model's blanket treatment of all sex workers as victims is more of an affront to our dignity than sex work has ever been in its entirety, based on the inaccurate assumptions built into its preamble and legislative history. If Parliament isn't willing to rewrite the laws, there are certain recommendations I would make that I can get more into later, specifically repealing parts of the purchasing laws and the advertising laws. Thank you.
Thank you. Now we have the last panelist from the Centre to End All Sexual Exploitation, Kathleen Quinn, please, for 5 minutes.
Oh, bonjour, and thank you for this opportunity. I am territories of Treaty 6 First Nations and the Métis people of Zone 4. I am a neighborhood resident in a central Edmonton community directly impacted by commercial sexual exploitation, drug trade, poverty, and homelessness. I serve as executive director of CEASE. This organization grew from the experiences of neighborhood residents working together with street outreach and safe housing agencies, law enforcement and Crown prosecutors, parents whose daughters and sons were exploited, parents whose daughters were murdered, and women and men who survived their years of commercial sexual exploitation. They wanted to be part of changing the conditions that caused suffering. At one of our meetings, we asked ourselves the question, what activity causes the most harm to the most people? We all named the source of harm to be the men cruising our neighborhood. They were preying upon and exploiting children and adults in vulnerable circumstances. They were harassing children on their way to school. They were soliciting women standing at bus stops or just going to the local shops. Together, we advocated with our City Council and Minister of Justice to address the multiple impacts of these behaviors and reduce the harm by holding these men accountable. Our police made it a priority to interrupt the activities of exploitation by charging sex trade buyers and pimps and traffickers. We advocated for more supports and services for children, youth, women, men, transgender, and two-spirit persons. Together, we created the Sex Trade Offender Program for first-time offenders with no prior records of violence against women or children. The goals are to provide accurate information about the laws and sexual health, educate about the dynamics of sexual exploitation, the sex industry and sex trafficking, and build empathy through stories of impact from mothers whose daughters were murdered and survivors of commercial sexual exploitation, regardless of the venue. Two men who are former sex trade buyers co-facilitate questions about healthy masculinity, respectful relationships, sex and porn addiction, and steps to making life changes. The Ministry of Justice designated this program as an adult alternative measures program and set the fees to be equivalent to courtroom fines. They decided that the funds generated would be returned to the community to help heal the harm, because it was the community who had raised awareness to police, government leaders, and the public. Together, listening to the voices of the women on our committee who had suffered sexual exploitation, we set these priorities: poverty relief, trauma recovery, bursaries for education, and public awareness. This is a form of healing, justice, and transformative investment. Just as we as a country are coming to terms with the impact of our colonial history, we must recognize that Canada has had unjust laws in the past that have discriminated against women in particular, and against those living in poverty, those in the 2S LGBTQ community, and Indigenous people. The PSEPA is not one of those unjust laws. Like any legislation, it should be reviewed and improved. PSEPA plus social investment can transform our society. We can respect the rights of those who identify as emancipated sex workers with high control over their working environment. The PSEPA does this. Persons selling their own sex services are decriminalized and immune from prostitution. We can protect the rights of those who are trafficked for commercial sexual exploitation. The PSEPA harmonizes with our human trafficking legislation and focuses on decreasing the demand that feeds the trafficking business model of buying and selling children and adults, primarily women, for profit. This is part of Canada's responsibilities as a signatory to the Palermo Protocol. We need to increase enforcement of the purchasing section. Buyers can rarely distinguish between a trafficked child or adult, or circumstantial sex trade participant, or an emancipated sex worker. We can uphold the rights of those trapped in commercial sexual exploitation by improving their socioeconomic circumstances and providing resources to heal, exit, and create an improved future that they want for themselves and their families. The PSEPA cannot achieve this without social investment and public awareness. We can improve the PSEPA legislation, increase social investments, and then review again in 5 to 10 years to see what progress we have made. Thank you. Merci.
Thank you. Thank you to all the witnesses for staying within time. I'll go to the first round of questions, starting with Mr. Cooper for 6 minutes.
Thank you, Mr. Chair, and thank you to the witnesses. I'm going to address my questions to Professor Benedette. Professor Benedette, in your opinion, is PSEPA working from the standpoint of targeting the source of the harm, namely buyers of sex and the profiteers involved?
Right, that's a good question. And I suppose there are a couple of ways to answer that. The first is to say that it's quite clear that enforcement across the country is wildly uneven. And we see some jurisdictions, and I see real momentum in Manitoba in particular, where the law is being enforced, and other jurisdictions like my own city of Vancouver, where there has been a deliberate refusal to enforce the law. And so in terms of whether the law is actually being enforced and enforced consistently across the country, I would say the answer to that question is no. Now, in terms of where the law is being enforced, what effects is it having? I think there are two effects. The first is that it is working hand in hand, these offenses, with the trafficking provisions to provide another tool for police and prosecutors in situations of exploitation. The other thing it's doing is I think it's actually starting to shift attitudes. And, you see the Manitoba Court of Appeal recently sentencing a man to 5 years imprisonment for buying a 16-year-old girl in prostitution. And that's grounded in the idea that purchasing another human being for sex is itself an offense against the person. You see Winnipeg moving to ban massage parlors because of their links to trafficking. Again, grounded in this recognition that it's not legal to buy another human being for sex. So those are my my observations, but I'd like to see, much more consistent enforcement of that provision across the country, and not this kind of artificial distinction that if that 16-year-old girl makes it to the age of 18, enforcement somehow falls away.
Thank you for that. And the issue of inconsistent enforcement, particularly in the province of British Columbia, has been noted by a number of witnesses and as a major concern. Do you have any recommendations on how that can be resolved, having regard for the jurisdictional issues?
It's a good question. I mean, I do think, jurisdictional issues aside, there's something a little bit concerning about police forces taking it upon themselves to simply declare that they're not going to enforce certain sections of the criminal code. Police forces can certainly have enforcement priorities, but if people are coming to them with complaints, they need to be prepared to use those offenses. And we know that the threat of actual prosecution is an effective tool. And if we're announcing to Johns, it's fine, go ahead, because we're not going to prosecute you, that's a very, very troubling message. So, I would like to see some statement that that's simply not on. This is an offense against the person. And if a police force said, well, we're not going to, enforce the assault laws in Canada because we don't think they're helpful or they aren't a priority for us, we would be really concerned.
Are you able, Professor, to speak about the experiences in other jurisdictions such as Denmark, Germany, New Zealand, the Netherlands, and so on, that have taken a very different approach? Are you able? It's a broad question, but we heard from two witnesses today from New Zealand who touted New Zealand as a model. They say it's worked. I note that New Zealand has dropped to a two-tier country in terms of trafficking in persons report by the Department of State due to an increase in human trafficking and child sex trafficking. Are you able to comment on any of those issues?
Yes, and it's important to note that the prior regime that the witnesses were referring to was a regime, there was criminal prosecution against the prostitutes themselves. And in fact, that's where the enforcement priority was. So New Zealand has not had experience with an asymmetrical model of criminalization. I would note in jurisdictions such as Germany and the Netherlands, there does seem to be increasing acknowledgement, even from those who were advocates for the sex trade, that those models have largely failed. And it's really become a containment exercise in shifting the sex trade around to more and more kind of isolated areas of town, setting up, for example, concrete stalls on the outskirts of Utrecht where people can drive into and conduct, transactions in cars. And Germany, acting to try and curb some of the worst excesses of the market. For example, there was a sort of vibrant trade there at brothels where you could pay a flat fee to have an unlimited amount of sex with the women there. Men would take erectile dysfunction medication over a certain period of time. And it's, we keep hearing about these outrages that the commercial market produces. There's attempt made to dial them back. But ultimately, the fundamental condition of men buying women for sex simply remains. And, I think even those who are arguing in favor of decriminalization would say that there are serious human rights abuses in places like Germany, the Netherlands. Denmark's sex market is 10 times the size of Sweden by population. And so we know, that demand increases and along with it, all of the abuses of women's human rights that come along with that.
Thank you. Thank you, Mr. Cooper, and thank you to the witness. Next, Mr. Naqvi for 6 minutes, please.
Thank you very much, Mr. Chair, and I'm going to be focusing my questions to our witnesses from New Zealand. Thank you very much for joining us. I don't have an estimate as to what time zone you're in right now, but I'm assuming it's the other side of the clock. Before I start, Dr. Abel, I know you were not able to finish your presentation. I have 6 minutes. I'm willing to give you about a minute or so if you have some concluding remarks before I ask questions of you and Dr. Armstrong.
Thank you very much. I wanted to just say that there's ample empirical evidence worldwide to show criminalization in any of its forms, whether it's criminalization of sex work activities, whether it's criminalization of some sectors of the industry, such as in legalization, where it's only legal and licensed, but everybody else, licensed brothels, but everybody else is criminalized. And parties such as the Nordic model, there's plenty of empirical evidence to say that they are not achieving their purported aims and they create a significant amount of harm for sex workers. Policies liable to fall down when it's not acceptable to those who are affected by it because they've not been consulted. It drives them underground where they're exposed to more danger. And it's predominantly the reason for the failure of policies focused on sex work. Sex work is constructed in a way which is meaningless to most of those who work in this occupation, but the sanctions it places upon them causes a great deal of harm. The best possible way to develop policy which is acceptable and effective is to develop it in collaboration with sex workers. The empirical evidence from both New Zealand and is the only legislative approach to show that sex workers are actually better off since its introduction. So that's what I wanted to end off with. Thank you for giving me that chance.
Thank you. And Dr. Abel, I will start with you. In earlier, you said that 5 years after the legislation was put in place, there was a study that was done. I think you conducted that study, and you found that that sex workers were better off, I think was the words you used. Can you share with us the metrics that you use to come with that conclusion that they were better off? How were they better off in terms of workplace health and safety, their personal safety and health, etc.?
Yes, we found that they were more able to refuse to see clients when they didn't want to. They weren't forced to see them by which happened beforehand. There was not an increase in the number of sex workers. So I think a lot of people thought that there would be a huge increase in number of sex workers working in the industry, but we did an estimation of the numbers and that hadn't increased at all. We found that more people were likely to report things to the police, that generally that they could people understood their rights and didn't have to put up with coercion, exploitation, and violence.
One of the concerns that we have heard in this committee as we have been reviewing our legislation is what I consider a conflation between human trafficking and sex work. There's this constant argument that's being made that somehow they're one in the same, and that a legislation like ours needs to be kept in place in order to prevent human trafficking. Can you speak to New Zealand's experience around how sex work is treated by way of decriminalization and how human trafficking is dealt with? And maybe I'll start with Dr. Abel, and I would like to hear Dr. Armstrong's perspective on that as well. Thank you.
We've had no cases of sex workers trafficked into New Zealand. The only trafficking experience we've had has been in the horticultural industry. So there are trafficking laws, and trafficking can be dealt with no matter what the industry. Under those laws, we don't need specific sex work related policy to deal with trafficking. In New Zealand, we have had cases of facilitation of young people, which have been classed as trafficking. Under the Prostitution Reform Act, we do criminalise third parties who employ the services of go to court in that regard. Perhaps Dr. Armstrong will have some.
Monsieur le Président, point d'ordre.
On a point of order, Mr. Chair, there's problems with translation. The sound cuts off, and so the interpreters are finding it difficult to do their work. Could we check the connection from Mrs. Abel?
Mr. Fortin, I've been given the information from the technical people here that it's just a connection. There's not much we can do because it's from New Zealand, but we will try to be patient. So maybe Ms. Armstrong just be a little slower so the interpreters can get it, and hopefully we won't have that gap. So.
Parlez plus lentement et peut-être tu lui demandes.
More slowly, but perhaps the person could speak in French, and that way there'll be no problem. It'll be more equitable, no?
Try. Maybe I can advise Ms. Armstrong if you can put your mic kind of between your nose and your lips. They say that usually works better, so just raise the bar. Yeah, perfect. Go ahead.
Okay, thank you. Thank you for this question. I think that the difference that we have in New Zealand is because we define sex work as work, we can quite easily distinguish between human trafficking and sex work in the same way that we can distinguish between any form of work and human trafficking. As we know, human trafficking can occur in the context of any form of work. As Dr. Abel noted, we haven't had cases of human trafficking in New Zealand. We do have protections through our human trafficking legislation, and also to protect against young people being exploited in the context of sex work. And as Dr. Abel noted, there have been convictions in that regard. I think our main concern in New Zealand currently, for those of us who would like to see sex workers being safer and being better protected, is Section 19 of the Prostitution Reform Act, because that it means that people who are here from other countries are working illegally. It makes it very, very difficult for people to report if they are being exploited. So to better protect against human trafficking, repealing Section 19 would be really important. Thank you.
Thank you.
Thank you to the witness, and I did give you the additional time for the time we had to pause for technical difficulties. Over to you, Mr. Fortin, for 6 minutes.
Thank you, Mr. Chairman. I find it that the testimony from New Zealand is very interesting. They're at the other side of the world. I checked my device earlier, so it's 8 o'clock in the morning in New Zealand. That's early. So thank you for taking the trouble to testify before our committee. I'm interested in what's happening in New Zealand because your system is quite different from ours. We've heard this from other witnesses, but Mrs. Abel, I'd like to hear from you first of all. You have some experience in what's happening in New Zealand. You know what's going on here. What, in your opinion, what explains the fact that the model here? Well, we have there are a lot of people who work in this sex trade here, and they're asking that we go ahead with the Nordic model. In your opinion, what would explain this?
Either, I think, Dr. Abel or Dr. Armstrong, if correct?
Oui, c'était pour Madame Abel.
My question was for Mrs. Abel.
I'm sorry, but I only heard the French and I.
Oh.
Trans.
You'll have to, I think on the bottom of your screen, there's an ability to switch translation. I'll let the clerk maybe give. Are you able to switch it to English?
Yes, I've switched it to English.
So, Mr. Fortin, I'll give you the ability to ask your question again.
Yeah.
Thank you. So, Mrs. Abel, first of all, I'd like to thank you for testifying. I know it's very early in New Zealand. You heard testimony from people here in Canada and who are attached to the Nordic model, the current model, and many people are hesitant to decriminalize things totally. So I'd like to hear your viewpoint. In your opinion, why are people fearful of decriminalizing prostitution and instead keep the Nordic model here in Canada?
Thank you. Thank you. I'm not sure of why people are, I think that people who advocate for the Nordic model, their voices have been sometimes privileged in debates. I'm not sure why it's in various countries, those voices seem above the empirical evidence. It'd be nice to think that evidence does inform policy, but it doesn't in many countries around the world in terms of sex work.
Vous voyez aucun avantage.
So you don't see any advantage to the Nordic model. You feel that decriminalization is the best way to go.
Thank you. Yes, I do feel it's the best way to go. If you look at the research coming out of Canada, as well as all the other Nordic countries, it shows that sex workers are still going underground. They do want to continue working. There's evidence it hasn't decreased them because sex workers are actually worse off in trying to protect their clients.
If Canada were to decide to decriminalize this and have a model similar to what you have in New Zealand, what recommendations would you make? Should we leave sex work completely open? How would we frame it? What would you recommend?
Thank you for that question. Yeah, in New Zealand, we have the Prostitution Reform Act. So it wasn't just a matter of scrapping all the laws that decriminalise sex workers. There are protections built into the Prostitution Reform Act, which I think are very good ones to have in terms of their ability to change their mind and break a contract if something goes wrong. They do, just because they consented at the beginning to do it doesn't mean that they can refuse. They can't refuse later. And so there's certain points within the act workers and do not have the traditional stand down period if they decide to leave sex work before they can draw the benefits. Section of the Act. However, what I would do differently was not have Section 19 because it causes significant harms to migrant sex workers. They are underground still in New Zealand because they are not allowed to, that's the only job that's singled out that they're not allowed to do on a work visa. And so we know that there's exploitation and there's migrant sex workers and they don't report it to the police because they don't want to be deported.
Okay. Tantôt, Madame Abel, je crois que c'est votre collègue.
I think your colleague, Ms. Armstrong, said that in New Zealand there was a distinction made between sex work and trafficking. Those are two distinct things. And you said that you protected young people, young sex workers, to avoid trafficking. Could you talk to us about the protective measures in place? What do you do to protect people against trafficking?
As trafficking, we've never had a case of trafficking of people into New Zealand. The only trafficking cases that have come up concern those who are under 18 years of age. So under the Prostitution Reform Act, you cannot, under 18s are not criminalised, but anybody who tries to, a client or a brothel operator who employs somebody under the age of 18 or anybody who facilitates can be is subject to criminal laws.
Quel type de sanction rapide?
Very quickly, what type of sanction? Oh, I think that's all my time. Is my time up?
Okay. Next, for 6 minutes, Mr. Garrison.
Thank you very much, Mr. Chair, and thank you to all the witnesses for appearing today. During these hearings, we often heard of the dire effects that might take place if we repeal PSEPA and its prohibitions, and usually those are described as an increase in demand in the sex industry, an increase in violence, an increase in exploitation, and an increase in crimes against children. And so, despite the fact we haven't seen that in the areas in Canada where the law is not being enforced, I want to ask our witnesses from New Zealand, again, I know they've touched on this very clearly, did you see any of these supposed inevitable outcomes of decriminalization in New Zealand? And I'll start with Dr. Armstrong.
Thank you. Based on everything that I have observed, read, heard in the years that I have been doing research on sex work, I certainly have not observed those outcomes. If anything, people who I have interviewed for my research, when I ask them, you know, what do you wish could change? Often what people will say is, I would like more clients. I'm not actually getting enough business. So the suggestion that, you know, there's been this huge increase in demand does not translate in what I've heard from sex workers at all. If anything, people say that they would like more business. In terms of violence, again, I haven't observed anything that would suggest that there have been increases in violence. Sex workers that I've interviewed will say, you know, the legislation is really helpful because clients know that I have these rights, and that if they mistreat me, you know, I have the ability to challenge that. So no, absolutely not. I haven't observed any of those outcomes.
And
I'll pass over to Gillian.
Maybe I'll just, as someone who's spent quite a bit of time in New Zealand, I think there's often a stereotype of New Zealand as an isolated country and kind of ignores the very large tourism industry that already exists in New Zealand. So I wonder if you have any comment on those kind of perceptions of New Zealand as being isolated and people not actually coming there.
Absolutely, thank you. I think that there's a real stereotype there, where we're seen as being this kind of isolated place in the middle of nowhere. But like you said, we have, you know, huge movement of people coming in and out of New Zealand. Certainly before the pandemic, the past few years, it's been a bit different because our border has been closed. But no, we're absolutely not isolated. We do have a lot of people moving in and out of our border during normal times.
Thank you very much. Dr. Abel, on the question of the increased demand, increased violence, increased exploitation, and increased crimes against children, in your research, have you seen any of these impacts in New Zealand from decriminalization?
No, quite the contrary. I prior to decriminalization, and definitely it is a completely different industry now. There were some members of parliament who were concerned about that before decriminalisation and therefore voted against it. And as I said before, have now said to us, you know, that their concerns were really unfounded. We've with rights comes the ability to create a safer environment, that people know that if they can't do things with impunity, that sex workers are very well aware of their rights and they utilise those rights. So it has made it a much safer place.
Thank you very much. I'll turn to Ms. Guo. You said that personally you hadn't seen a lot of change after the enactment of PSEPA, but I wonder if that reflects the experience of others you know who are involved in sex work. Has the provision, say, limiting public places where sex workers can operate made work more dangerous? Has the restriction on advertising made communication less easy and therefore more dangerous?
Public places, no, because every sex worker I know advertises online. So that's not really an issue. Advertising, I've heard claims that it's supposed to, you know, you can't be as explicit, you can't list your rates, but that really hasn't reflected my experience or the experience of other people I know. While third parties are prohibited from publishing our ads, they still do so anyway. There's a lot of money in it, and it just continued the way it was before the laws.
And I've just got 1 minute. I want to go back to Professor Benedette, whose testimony I very much appreciate, and I understand, Professor Benedette, where you're coming from. But my question to you really is, do you actually think that it is possible, using the law, to actually eliminate demand for sex work?
I think it's necessary to have a law that declares this behavior to be criminal and not to normalize it. I don't think it's possible to use the criminal law to eliminate sexual assault. I don't think it's possible to use the criminal law to eliminate domestic assault or coercive control or any of those behaviors. But I think it is necessary to denounce those behaviors and discriminatory against women. So no one should expect the criminal law to completely eliminate any behavior. We don't eliminate homicide by criminalizing it and giving people a life sentence. It's simply a necessary tool in the toolkit. And once you take that away and say it's absolutely fine to buy a woman for sex, then you've normalized that behavior. It's no longer sexual harassment. It's no longer a practice of sex discrimination.
Thank you, Ms. Benedette. Next, for 5 minutes to Mr. Morrison, and then, for 5 minutes.
Well, thank you, Mr. Chair. I want to thank all the witnesses today for coming here, and especially those from New Zealand. Thank you for participating. My question for Ms. Quinn, it was interesting and important for the committee to hear your research of the individuals who have been sexually exploited, especially in the Edmonton area. And I'm wondering, of your work that you've done, what you feel about the demand. You talked a little bit about the demand and where that demand correlates with children, younger children, or is that what's happening in Edmonton, or is it more adult women, or who is the exploitation? When you did your research, where did that focus on?
Well, thank you. There is a demand for children. We've just had recent arrests in the past 6 months of young people who lured, groomed, recruited, and sold children. So that demand is always there for young people. The majority are over 18 to 30 years old. And again, we see boyfriends selling girlfriends. We see a number of people posting their own ads. But we have to acknowledge that children and young people are the target. We also have to acknowledge that in general, violence against women has not decreased in Alberta or in Canada, and that this is also reflective in the sex industry. I think what we have noticed is that prior to PSEPA of Edmonton, we had over 41 women and transgender persons murdered between 1986 and 2014, with only 11 murders solved. Since PSEPA, we have had 2 young women murdered. Both were killed. One was strangled by a sex trade buyer. She was a young woman from Quebec who had come to Edmonton. And the other was murdered in a hotel. We do have a strong relationship with police and community agencies where there has been more reporting of violence. We have a specialized victim service unit, and we have worked very hard to build trust among people to know that they can report violence. We will walk with them through reporting to police. We will walk through them through the traumatizing criminal justice system. We will help them with everything they need. And so I think these are critical factors to have in place and as part of what is working well in Edmonton.
Oh, thank you so much. Well explained. And for Professor Benedette, we've had one witness that came to us when we asked what would happen if PSEPA was repealed, and just a one-line answer was horrible. I know that you were asked that question just a minute ago briefly about what would happen. We live on a fairly large border with the U.S., and if we legalize prostitution in Canada, what damage would that be? It's a bit different than some of the other countries that we've talked about. I wonder if you can just give me briefly what you think would happen if we actually repealed PSEPA.
Well, I suppose three things would happen. The first is I'm quite convinced that the demand for prostitution would increase, both domestically and from men in other jurisdictions who will travel to Canada to take advantage of that market. We certainly see that in other jurisdictions in Europe, where buyers do move to locations where prostitution is legal. In terms of child prostitution, I think it's important to recognize that if you decriminalize the purchase of adult women for sex, it is then open to any man who is charged with purchasing a child to argue that he honestly believed that the girl was 18 years of age or older. That becomes a defense. Now, with the way it is structured, even if that defense is successful, there's an include just an adult, and you can be convicted of an attempt to do that. So it does have significant impacts in terms of child prostitution. And then I think the third thing that's so often overlooked in this is the effect that it has on the equality of women generally. That's account at the brothel, when, you know, going out to the brothel just becomes another form of entertainment for men, when billboards can openly advertise. It says something about the condition of Canadian, or the condition of women, and in this case, Canadian women in society. And so my view is that all women are harmed by an environment that does that.
Okay, thank you so much.
Next for 5 minutes, Madam Diab.
Thank you very much, Mr. Chair. First, I want to ask, and I'm not sure if the committee has them, but before the time is up, I want to ask both Dr. Abel and Dr. Armstrong if you can send the committee your research or any notes to the committee that you have not sent. I don't believe I've seen them, but if they haven't been sent, would you please be able to send those this week to us, because we're just about to wrap up this study. And I'm Nadia Gu. I would like to ask you, could you please provide your recommendation, or what are your recommendation? I know you've spoke about you personally have not seen any difference before PSEPA and after PSEPA, but I'd like to sort of ask you, what are your recommendations to us as a committee? We've often heard from a number of witnesses that sex workers are victims and and need to be saved, or that they're exploited, or so on. Can you tell me from your perspective your comments on that, and as well, what recommendation do you have for us?
So I'm a bit hesitant about the full-blown commercialization of sex work in Canada. I know in some jurisdictions like Spain, for instance, there's been increases in sex trafficking. However, I think it's important that we recognize that people do this consensually, and we're adults and we can make that choice for ourselves. So if it was up to me, I would repeal all of PSEPA, just because the legislative history and the preamble and all the internal logic of the bill is based on the premise that people can't consent to selling their sexual services, which I believe is wrong. But I do recognize the importance of maybe having replacement laws that, for example, might keep the procuring section in place. I understand it's difficult sometimes to prove sex trafficking under the sex trafficking provisions. So yeah, and then for the material benefits section, I think the exceptions right now are pretty good, and the way they've been interpreted in the NS case at the Ontario Court of Appeal made sense to me. And I don't know, I kind of struggle with it, because I do understand that, like, while I worked for myself and I found it pretty easy to do so, other sex workers might benefit from having management handle their bookings and their advertising and just only focus on meeting clients. So I don't really know. I struggle with it. I struggle with whether the material benefit sections should say or not.
Ms.
So-
Gu, would you mind answering this question for me? What, in your opinion, and you know, whatever you can, what makes a person join the industry? How does somebody enter the sex work industry?
For many different reasons. Personally, for me, I was curious about it. I wanted to explore my sexuality and I don't know, I just wanted to see what it was like, and also obviously the money, because you can make a lot of money in a very short period of time, and you can control your own hours. You can have total control over your working conditions, which was not the case, for example, when I was articling. During my articles, you know, I made a fraction of the amount of money I made in sex work. And on top of that, the conditions weren't great. I experienced sexual harassment continuously in the beginning of my articles. And that wasn't something I could say for what happened during sex work. So what makes people enter it? It's just the flexibility, the independence, and the ability to.
So thank you for that.
Yourself.
Appreciate you being candid. Dr. Abel, can I ask you a question from the research you've done, or Dr. Armstrong? I'm not sure, but can you, from the research you've done and the extensive experience you have, I know you've clearly indicated that decriminalization will result in healthier and safer sex workers, but will you please publish any work that you have to the committee? But the question that I have is, can you comment on the harassment from the public and stigma of sex workers prior and post decriminalization, to your understanding from any research you've made?
And very quickly, otherwise I'll ask if you can submit that answer to the clerk in writing afterwards. Sorry, we can't hear you. Dr. Abel, since we're also out of time, I'm going to ask if you could submit that answer in writing to the clerk. We'll have that your answer included in the report in that manner.
Thank you to all of you for attending.
Yep. And thank you, Madam Diab. Thank you to all the members. Thank you to all the witnesses that are in attendance here today. We now will be ending this meeting or suspending this meeting as it goes to an in-camera meeting. And
Monsieur le Président,
Mr. Chair, we're not doing another round of questioning?
Drafting, and we're already 9 minutes over, so I apologize.
Oui, mais vous avez donné l'opportunité.
But you gave my colleagues an opportunity to, on the Liberal side, on the Conservative side, to ask questions. So I think that the Bloc Québécois and the NPD should also have the right to speak. I would suggest that we complete the round.
And I mean, we will be another 5 minutes if the committee wishes. I can. It just impedes out of drafting instructions. Mr. Garrison saying he's okay with it, and so Mr. Fortin, if I can to make this decision, I don't like taking anybody's time. I try to be as balanced as we can, but in light of this, I'm going to have to conclude it right here, and then next time I will do my very best to ensure that you get your time. But I was very fair and liberal, I think, in your time in the first round at this time. So I'm going to suspend. You have links to the new in-call Zoom. So everyone, Mr. Nackley, Mr. Moore, Mr. Fortin, and I think that's it from our panelists. And again, thank you to everyone else. Please re-log in under the new web link that's been sent to your P9s.
Thank you.